Hello. So today I'm going to be talking about the factors that impact charging decisions, and I got a lot of my information off of the US Department of Justice.org. So prosecutors usually pick the charges to pursue depending on a lot of factors. They all have the goal of maintaining and balancing justice with practicality. So in the beginning, they usually examine like everything that they've gathered from the law enforcement. So like witness testimonies, other evidence, really just everything that they have gathered. The nature and the circumstances of the crime are important factors because the more serious acts with clear evidence are more likely to result in formal charges. Prosecutors, they also analyze the defendant's criminal past. So like, have you gotten in trouble before? Have you not? Prosecutors are guided by legal and ethical norms. So they have to ensure that the charges are all fair and just. They avoid overcharging and pursuing cases that lack validity because, I mean, obviously they do that. So charges are made against those who are suspected of committing crimes. The procedure begins when authorities investigate a case and collect evidence that a person may have broken the law. Once enough evidence has been gathered, it is brought to the prosecutor's office where prosecutors examine it and then determine whether there is reasonable cause to think that the suspect committed the crime. The decision to press charges is based on the strength of the evidence and the severity of the offense and the possibility of obtaining a conviction. If the prosecutor decides that the case is solid enough, they will file formal charges, which begins off the legal procedure against the suspect, who will then become a defendant. The charges specifically and the suspected illegal activities serve as a foundation for the subsequent court processes in which the defendant will have the right to defend himself against the allegations. So charges against persons may be pulled for honestly a lot of reasons, including the prosecutor's personal choice. If they think it's not valid, they can easily pull that. Insufficient evidence is a common explanation. So like where there's not enough or it's really not proper, like it's not the best. Or if new information that exonerates the evidence that they had that got the person in trouble, then that can make things get pulled. Charges may also be dismissed as a part of a plea bargain or if prosecuting the case is not smart. And basically it's usually for minor offenses where the offender has demonstrated like that they are doing better or yeah. So there's really just a lot of reasons that things could be dropped, but I guess it kind of just depends on the severity of the case. It usually happens with smaller cases, but if you have any questions, let me know. And yes.